Hi everyone, I am Heather Wardrope and I'm an Alumni Engagement Officer here at Robert Gordon's University. And today we are joined with David Christie for our Decafe debrief on contracts and concurrent delay. So this is an extension from our coffee morning that we hosted recently, and we're just going to look further into what was discussed during the coffee morning, as well as highlights and potentially future topics as well for our future coffee mornings. So as I said, I'm joined with David Christie here. Hi David, how are you today?
Fine, thank you, Heather. Thanks for having me along. I thought it was a great coffee morning. I don't know how you found it, but it basically did more than I even expected it to do.
I thought it was fantastic. Like the people that were there, they were joining us from all over the world. Like I know people from Hong Kong, UAE, Australia, obviously Scotland closer to home. But it was very interactive. It was very interesting. For those who don't know me, I don't have no insight into the construction law industry. I'm an engagement officer at Robert Gordon's University, but I found it really interesting, and I think I've learned quite a fair bit about the whole industry now. Could be a potential future student for you. Who knows? But no, I thought it went really, really well. Really interesting to see what other people's thoughts were on concurrent delay.
And of course, and this is the plug for the alumni, is the alumni have already got a qualification with us, and there's an alumni discount if you do any further study. But I thought, and you thought, since a lot of people were asking for the slides and also for a recording of the session. Now we don't want to, we didn't record the session because I think it's not that sort of event. We want people to have a freewheeling discussion, and I think it was great to see how the extent to which we achieved that. And I think one of the consequences of that was that I didn't spend as much time on my slides as I perhaps thought I would. But people want the slides, and I thought it was quite useful then to use this session just to run through the slides again, and also just pick up some of the themes that emerged from the discussion, naming no names, but just a few of the general points. So if I just crack on, my contact details are there if anyone has any questions arising from that, or ideas for the next chat, because I think one of the key messages from now is that we're definitely going to repeat this and probably look in more detail at concurrent delay and similar subjects. So my slides are there, my contact details are there on the slides. In terms of what I'm going to do, I'm just going to quickly run through the position in terms of the law around concurrent delay. During the session, I did what I called a Pecha catch-up. That's inspired by the Pecha Kucha presentation style, in which a speaker runs through 20 slides, each slide taking 20 seconds. I don't have 20 slides, and I may take more than 20 seconds for each slide, but I thought as a way of just pulling together some of the threads in the law around concurrent delay, it would be a useful way to do it, but not having to be a long period with just me droning on about various case law. After the Pecha catch-up, I quickly pulled out some of the hot topics which are around in terms of delay and concurrent delay at the moment. That's not taking account of what was discussed in the coffee morning itself, but to partly drive the discussion. And then what we didn't get onto, and I think it's a sign of the freewheeling conversation we did have, was some discussion of practical solutions. I have a few thoughts on that, and that's something I think we can pick up at the end, about thinking about the sort of issues that arise and the sort of discussion we can have about how you can solve those at any future coffee morning. So in terms of the Pecha catch-up, then the definitions on the slide. The first question really is, what is concurrent delay? And that was a question that was asked in the coffee morning. And the answer I think we can now reasonably comfortably give is the answer that John Marin gave in a paper in 2012 given to the Society of Construction Law, which you can find on their website. And he said that a useful working definition of concurrent delay in this context is a period of overrun which is caused by two or more effective causes of delay which are of approximately equal causative potency. So if you have two causes of a delay which are equal causative potency, then you may have concurrent delay. This is the view of a leading construction QC in London, but it's now also been accepted by the courts, most recently in the North Midland against Side and Holmes decision, which I'll touch on in a little bit. But that was discussed and agreed by the Court of Appeal in England. So this is the definition of concurrent delay. The position in Scotland on concurrent delay generally, and even in terms of definition, is slightly different, and so it'll be interesting to see if that develops at all in Scotland. But I think, at least for English law purposes, this is the definition. One of the questions asked during the session was about when the delays arise. I think if you look more broadly at the case law around concurrent delay, it doesn't necessarily matter when the delays arise. The question is when they affect the end of the project, when they affect the critical path. And I think that would be the answer to that particular question. There are, however, wider questions around cause and effect and causation of delay, which I think are still to be resolved. So I think that's something we could look at in a future session. The big question then is, if you do have concurrent delay, what is the effect? And that's an area where the law in Scotland and the law in England and Wales is different. So in England and Wales, the position is set out now as in Walter Lilly against Mackay, where Mr. Justice Aikenhead said, I am clearly of the view that where there is an extension of time clause such as that agreed upon in this case, and where delay is caused by two or more effective causes, one of which entitles the contractor to an extension of time as being a relevant event, which is a defined term in that contract, the contractor is entitled to a full extension of time. So under the English and Welsh position, if there's a relevant event, that is a delay for which the contractor is not responsible as defined within the contract, then the contractor is entitled to the full extension of time, whether or not there is also delay which is caused by the contractor. The position in Scotland is different, and that is decided upon in the case of City and Shepherd, and that is one where if there's a situation which could, as a matter of language, be described as one of concurrent causes in a broad sense, it will be open to the decision maker, which could either be the architect under the contract, arbitrator, adjudicator, or judge, due to looking at that decision at a later date. They will approach the issue in a fair and reasonable way to apportion the delay in the completion of the works occasioned thereby as between the relevant event and the other event. So in Scotland, the position with concurrent delay is that if there is concurrent delay, it is open to the decision maker to decide that that is more attributable to one than the other, but to spread out the delay between the two events rather than simply doing an all or nothing, such as is described in the English position. And that has led to a difference of approach in Scotland as opposed to in England and Wales. One of the most significant differences between those two jurisdictions in construction law. I think if I read the literature correctly, the Scottish position seems to be the one which is more accepted internationally, or not that it's accepted internationally, but the Scottish approach seems to chime more with the versions accepted internationally. England, of course, being an important jurisdiction in construction law terms, has a lot of force. The most recent discussion of delay came in the case of North Midland against Side and Holmes, mentioned already. This, I think, is the house which was the focus of the in that case. And that case is interesting because the discussion focused on a possible concurrent delay, where you had, in relatively conventional terms, delays by the contractor and the fact that the roofing and the lighting works took longer than had been planned, but also a relevant event delay that lay within the employer's ambit, which was that there was poor weather which slowed down the progress. So you would have potentially there two causes of any delay, so potential concurrent delay. However, in that case, the clause, the relevant clause in the relevant contract had been amended to say that any delay caused by a relevant event which is concurrent with another delay for which the contractor is responsible shall not be taken into account. So essentially, they contracted out of the position with concurrent delay, so that there had to then be, if there was a contractor delay, the contractor delay essentially became paramount rather than the employer delay. And so the concurrent delay situation did not arise. That's an interesting decision. I'll come back on to the impact of that in a moment. The other question which arose out of this amendment to the standard form was the impact of this on what's called the prevention principle. Now, the prevention principle goes back well over 100 years of case law, but it was well picked up and defined in the quote which you'll see on the slide from Lord Denning, which says it's well settled that in building contracts where there is a stipulation for work to be done in a limited time, if one party by his conduct, it may be quite legitimate conduct such as ordering extra work, renders it impossible or impracticable for the other party to do his work within the stipulated time, then the one whose conduct caused the trouble can no longer insist upon strict adherence to the time stated. The time becomes at large. The time becoming at large means that instead of having to complete by the date specified in the contract, assuming there is one, the obligation of the contractor becomes one to complete within a reasonable time. So that then gives significant latitude to the contractor, albeit not unlimited latitude to the contractor, to finish the works within reasonable time rather than the specified contractual completion date. The other very significant consequence of that is that if time becomes at large, then any entitlement to liquidated damages which the employer might have for late completion also flies off. The reason for that is not entirely clear, but seems to have arisen in case law in the 70s and early 80s, and that's something that's been looked at in a bit more detail more recently. So the prevention principles become a little bit of a hot topic there. There was an attempt by Holmes to argue that it would override the attempt to amend the contract. Lord Justice Coulson in that case said no, it wouldn't. There is a bit of a question about exactly what the prevention principle is then, something that I'm looking at in my own research. And one of the reasons for it being important is that if the prevention principle operates and time becomes at large, then there's no entitlement to liquidated damages. The cure, of course, to that, which is found in most building contracts, is to have an sort of time mechanism so that if there is a delay event, as we see with concurrent delay, the contractual completion date essentially is amended rather than just being taken away altogether. So you would insert a new date reflecting an allowance for the delay in place of the old date. What then are the hot topics? Well, in advance of the event, the chat, I circulated this paper from Lord Justice Coulson, which costs £3, which I think is a reasonable step, on the Society of Construction Law website, so easily accessible. I realise I do not see any of that money myself, but it supports the work of the SCL, and I think that's well worth it, as well as being worth reading that paper in itself. It's a good summary of the overall position in the law today, so if you're interested in it, please do go and read it. And I think the key points for discussion were the ones on the slides. Lord Justice Coulson picked up the all or nothing point. You have in England all or nothing. If there's a relevant event which gives a delay, then the contractor gets the full extension of time, so that's all or nothing. Similarly, there's an all or nothing effect with liquidated damages, LADs, where if the prevention principle kicks in, then there are no liquidated damages. The prevention principle only kicks in if there is no extension of time mechanism, so part of it a go at arguing against the extension of time mechanism. Now, Coulson himself acknowledges that it would be quite a strange contract where there is detailed liquidated damages provisions, but no detailed extension of time mechanism. Usually one would come with the other, simply in the way of the effort required in terms of drafting and the care that's gone into drafting it, but that is a possibility. I think it's seen as being a bit odd that the effect of even a short delay to the works, 1 day of delay which triggered the prevention principle, would then give no entitlement to liquidated damages, seems somewhat disproportionate in terms of the impact compared to the length of the delay. That seems to reflect the case law. Coulson discusses some of those issues in that paper, and again it seems difficult to imagine in which case it would arise, because usually you'd have an EOT mechanism, an extension of time mechanism, and in any event to overturn the case law would seem to be tricky, and to work out what you would put in place would seem to be tricky too, but that is maybe something to think about in the meantime. There is also a bit of a question about whether you do have prevention if you have concurrent delay, because on the one hand, the contractor could say they're being prevented from completion by an employer event, a relevant event, But on the other hand, the employer might say, but the contractor, even if the employer event had not occurred, the contractor still would not have been prevented from completing because they did not complete in time because of the contractor's own fault rather than because of something which was attributable to external causes. So there's a bit of debate in the case law about exactly what happens. The dicta from Walter Lilly, which I cited earlier, gives you that all or nothing on a relevant event benefiting the contractor. But then there is some other dicta in other cases where there seems to be a suggestion that you need to actually have a cause and effect where the contractor has to actually be prevented, and they wouldn't be prevented, it is argued, if they were also in culpable delay themselves. To some extent, that may be academic, because what we see from the North Midland case is a relatively narrow interpretation of concurrency being agreed. This is certainly my view. It may not be the view of others. It seems to be that there's a narrow interpretation of concurrency, and it's quite easy to contract out of the prevention principle. So if those two events arise, it might be difficult to see a case in which there is held to be concurrent delay and no prevention principle which has been contracted out of. So it may be that it's difficult to find a factual situation where that occurs. But that doesn't mean to say it won't. One of the questions was almost inevitably about the pandemic and the impact of that. And I think we will see quite a lot of cases about that, and given the volume of cases, there may well be these unusual situations arising which give the courts an opportunity to consider how to resolve some of these final issues more definitively. One of the other points which always comes up is about how we prove and how we demonstrate delays. There was an excellent webinar given by Lucy Garrett, QC of Keating Chambers, which I would commend to you as well. Her slides are available on the Keating Chambers website, and there was quite a lot of detail about how she would advise parties to proceed on that basis. And I think I took from it, and I'm paraphrasing because I noted it down as I was listening to the webinar, she said in terms of proving delays, it's not difficult, just complicated. And I think that's quite a useful way to think of it, maybe in terms of demystifying it. I will leave you to go and look at her slides rather than trying to piggyback off her work. But being an academic, during the coffee chat, I did highlight the Greek rules of rhetoric as a structure for thinking about how you persuade people. And they're a structure for how you persuade people, but they provide sorry, just a bit of a jump there. They provide a useful way to break down a message that you're trying to convey and test it against various criteria. For the Greeks, there was three key criteria. There was the logos, the ethos, and the pathos. These are not equal, albeit the slide they're of equal size. They're not always equal in every case. They're to be appropriate for the message that you're trying to convey. So when you think about delay analysis, you should be thinking about, to some extent, about logos, which is the logic and the structure of what you're saying. That's probably inherent in analysis and being important in delay analysis, of showing the logic and the logical force of what the position you're analysing is when you're trying to demonstrate it. But you also should keep an eye on pathos, which is the emotional quality of the message. Now, obviously, delay analysis can look very dry and very technical and quite scientific, and it is all of those things. But if there's a way to try and simplify, a way to try and demonstrate a case convincingly, see if there's a way to weave in a little bit of that extra information, not necessarily in the charts, but in the way that it's presented and the way it's talked about. And that overlaps quite strongly with the idea of ethos, which is the stance, the position of the person delivering the message and their credibility. And you'll see that these things all overlap. To some extent, your credibility comes from having a very logical delay analysis. To some extent, the emotional connection comes from being able to put your position across convincingly and clearly. But if you can think about those various building blocks within your delay analysis, then that's a useful way to think about it. Certainly one of the things that was picked up in the chat was about various methods of delay analysis, the benefits of the SEL protocol, and so on. And I think that's quite a useful point that we might want to come back to together. In terms of everything else that was picked up, I think we've probably covered most of them in what I've just said. one of the interesting things was before the pandemic, BIM was the big talking point in terms of developing in construction law and construction industry more generally. How will that affect delay analysis? I think that probably boils down to one of the key things which I think underpins all the methods of delay analysis, which is the quality and the quantity of information about establishing what was the delay, where it arose, and what was done about it. And the quality of the information in a BIM model is likely to be very good. So I think BIM models are a useful way to store this and organize the information available for when you come to delay analysis compared to some other methods, which are probably more technical than I'm aware of. And I think the other point which was picked up was about the treatment in other jurisdictions. One of the benefits of being a Scottish lawyer is that we have English law as an automatic comparator, and sort of touched on the difference between Scotland, England, and Wales in this area. But there are other jurisdictions out there which have slightly different approaches, so that I think would be something we could discuss later too. And then there was, in terms of pre-reading, there was a good paper also in the Society of Construction Law about causation from one of the QCs, which I could share and we could discuss later if people are interested. But I'm very interested to see if anyone else has any thoughts or comments too.
So I've actually just got a quick question for you there, David. In regards to the English and Scottish laws, you said that they're different, but other countries tend to follow the Scottish way of thinking with this law. Why is it? Why do like, I don't know if you would know the answers, but why do England and Scotland have different methods for this law, and why is it the Scotland one that's more popular in other countries?
So I think just to be clear, they have not followed the Scottish approach in the sense of going, Scotland do this and that's the right way to do it. I think it's more fair to characterise it as they do this and the Scots also do something in that vein. So it's a shared idea. We happen to do it in the same way here as it tends to be the international approach as well, but it's not necessarily one following the other. The Scottish courts they looked at some international cases in the leading case law, but they didn't adopt their approach because that was the way it was done internationally. Similar, the other international approaches haven't said Scots do it this way, that's much better. It just happens to be that seems to be where the consensus is.
Okay.
Why are England out of step? If that is the case, and again, this is relatively preliminary, and I think you see that in the Coulson paper, he flags up this all or nothing approach is probably the key there, which is that it seems a bit weird that the contractor can be in delay themselves but still get a full entitlement to an extension of time if there also happens to have been a relevant event.
Okay. I did actually have another question around this, but it's completely slipped from my mind. Now I want to go back to the ethos, legos, and pathos. Is that right?
Yep.
When do you know when to apply? She said like each level isn't equal to each other. It's all different. When do you know when to apply which level to each circumstance?
Yeah, that's obviously a big question. The Greeks would have said you have to work it out for yourself, and I think this is a way. It doesn't provide an answer to that question. It provides you a way of thinking about answering that question, which is you do it when it's right, but you have to reflect quite hard on it and go through various iterations. If people were in my design thinking webinar a few weeks ago, I think it's a similar process to that of getting different views, reflecting, testing arguments, bouncing them around as much as you're able to test and see if they come out right. And it's really a bit like about some of the stuff around design thinking. It's a framework for thinking rather than necessarily a framework for telling you what the answer is. And it struck me that in the design thinking webinar, there was the elephant with the rider and on the path, and I think it's a similar idea here where you have the rider is something like the logos, the rational bit. The pathos is the elephant, which is strongly driven by feelings, not driven by feelings, but in which the motivation and the emotional content come, and then the ethos is to do with the path, the environment, and the credibility of what is being said. So it's a similar breakdown, and it's a way to try and deconstruct what you're doing and test what you're saying to make sure it meets those criteria in the right way. But they don't tell you which is the right way, because it depends a bit on who the messenger is, who the person receiving the message is, and what the message is. And those are all things that you have to bear in mind when you're thinking about it.
Okay, and I just kind of want to revisit the coffee morning. There were some great points risen throughout the coffee morning, and obviously you've got a better understanding of over these points than what I do. So what were the highlights from the coffee morning? What were the key points that you think we can talk more about this? This can actually lead to a really good discussion.
I mean, I think for me, it's the bit that I understand the least is the actual way of demonstrating delay, because that's the point at which the lawyer provides the framework for it, and then it's up to the technical folks, such as the people in the coffee morning, to really fill in the blanks. And it was interesting the amount of times it comes down to these ideas of what the information is and how you present it. So I think there is definitely something in that. If anyone had any thoughts about what they find persuasive, why are they finding it persuasive, is there a better way to do things? Those kind of things are quite interesting, but I'm not sure. So I think that's worth kicking about, and that's the sort of thing I was thought might be worth some discussion, and almost using something like the rhetorical tropes and the rhetorical style as a way of breaking down your existing practice and seeing where is it good and where is it bad, how could you make it better. I think that kind of reflection is always quite a useful way to look at existing practice in a different way. So I think that would be the next step. I think that would suit the sort of people who came along, and it would tell me something. And then I think further down the line, I'm doing research at the moment in the prevention principles, so maybe to report back when I've got to an answer on that, and that'd be a useful way of taking my ivory tower stuff and applying it to a practical situation. And then I think, again, maybe once we see how things are panning out with the pandemic, another look at flexibility and contractual interpretation would be useful. So I think that's at least 3 more coffee mornings.
Fantastic. I'm sure people will be very excited for that. As I've gotten lots of emails back asking when the next one is, which we do plan to actually hold at the end of the month. So keep an eye out for that dates there of the next coffee morning. And is there any other points about that maybe was mentioned at the coffee morning that you want to bring up, or is there any points that you think would be good to further delve into at the next coffee morning? I know one for me is definitely hearing what everyone's thoughts are on COVID-19 and the impacts it will have within the construction industry, and how they will affect the future development of contracts. Or like, what happens if we have another pandemic? Is this something that will be implemented into different contracts? So that's one of the areas that I would like to hear more discussed at the next coffee morning.
Yeah, I mean, it was one of the things I was quite keen not to talk about the first time round, because I think the first time round when we were trying to get people to come along, I think there's been a lot of what does COVID mean for my business type discussion. But I think maybe when now things have started to settle down, hopefully, a little bit of what are the lessons to get from COVID. So, for example, force majeure clauses, the list of relevant events, those things are pretty what's called boilerplate. They tend to be standard wording. They don't tend to be subject to huge amounts of attention when contracts are being agreed. And I wonder if that view is changing and what sort of things people are thinking they should put in their contracts for the future. The danger, of course, is you fight the last war rather than planning for the next one. But I suspect people are much more conscious of the sort of catastrophes that can occur now. So what catastrophes are they planning for the future?
I mean, I think
Which is pretty bleak, but we should try and be positive and proactive about this.
I think one of the good things is here within Scotland we've now started going into phase 1 of coming out of lockdown, which is quite good. We're now allowed outside to sunbathe now, which is great, or read our books outdoors. But it's not just the construct. Like, obviously, every area is being affected by COVID-19. But what I would quite like to see is what's the learning points of COVID. So not only how it affects what can we take from this to apply to our businesses, to help with future development. So I don't actually know how much this actually affects the construction law industry. But with supply chain management, because obviously that was an area that's been massively affected, how's that going to impact with it? And like, does that is there much connection between the contracts and supply chain? David,
Yeah, I mean,
before I start rambling off on a completely different topic.
yeah, no, I mean, well, one thing that strikes me is that we could, we don't, we focus this first one on our construction law alumni and friends, but obviously, I think now, Heather, you're planning to have coffee mornings with some other groups of alumni. It'd be interesting to see whether there is what the emerging views are, and perhaps having some crossover events as well, where we look at what's happening. I mean, the supply chain is obviously very important. There's construction has a big supply chain, not just within the construction projects itself, but in terms of buying in the materials and the kit that is used on a site. So supply chain issues are integral to construction issues. But also in terms of commercial issues, if you speak to the MBAs and all that, if they have different views, I think it's quite useful for people to understand the different ways of thinking throughout the industry. That's one of the great things about having the coffee morning, is that I come in with my legal academic hat on, but I can understand what people wearing different hats say, and we can compare notes and gradually build a bigger picture. One of the issues often is that people might expect one aspect of people's thinking to solve all the problems, but you have to solve them all together. COVID or prevention issues, delay issues, they're not just a legal issue, they're not just a commercial issue, they're not just a cultural issue, they're at least all those three things bound up into one, and it's trying to understand each of those different positions that takes us towards an answer.
That's perfect. And just to wrap things up, David, have you got any final thoughts on a concurrent delay? Sorry.
Just that I think it will continue to bounce around. It's obviously an area of interest because it is difficult, even if it's not. No, because it is complicated. I think it's the sort of thing that it's worth discussing, because that's how you try and simplify it. So if anyone has any other questions or comments or thoughts, then our emails are now on that slide, and welcome to hear them. And we will think about, the other thing would be if people found it interesting to get the reading in advance from the last one. If so, I can provide some reading in advance of the next one, because I think that was quite useful to prime some thinking and get people thinking about what we were going to discuss.
Perfect. Well, that comes to the end of our little podcast here. I hope you guys enjoyed it. I hope you found it useful. As we said, if you have any other information or feedback or any other topics that you want to discuss at our next coffee morning, please just let us know. Send us an email, and we'll make sure we try and get this discussion on the go at the next coffee morning. But thank you for listening. If you have any questions, let us know, and enjoy the rest of your day, guys. Thank you.